I'm Caroline Calio. I came down from our West Hartford office today, and I'm going to talk to you about the Connelly case, which is a recent U.S. Supreme Court case. As you might assume, not many estate planning cases actually make it to the Supreme Court, so this particular case has garnered a lot of attention. And further, in particular, this case really impacts many closely held businesses and their succession planning, so it's been on a lot of people's radar. As we all know, designing the transition of a closely held business is an important part of any business owner's planning, right? It's very good practice to draft a shareholders agreement or a buy-sell agreement for the owners. That has a lot of different purposes, one of which is, of course, preventing outsiders from owning any shares, providing for the smooth management and operation of the company, setting the value of the interests when an owner passes away, and making sure that the deceased owner's family is made whole when they are no longer here to own those shares. Usually buy-sell agreements are either structured as cross-purchase agreements, which we'll talk about in a second, or as entity purchase agreements. And as the name suggests, that's just where the company is obligated to purchase and redeem the shares from a shareholder at his or her death. That lands us squarely in the Connelly case. This case is centered on a company redemption, and the facts are as follows of this case. There were two brothers. They owned all of the outstanding shares of a company. One brother owned approximately 77%, and the other one owned about 23% of the shares. To ensure that the shares stayed in their family if one of them passed away, the brothers entered into a stock purchase agreement. The agreement required the company to purchase a deceased brother's shares if the survivor didn't purchase the shares first. The brothers clearly anticipated that the surviving brother would not purchase the deceased brother's shares because the company went out and bought a life insurance policy on each of the brothers. In fact, the case is noted that the brothers always intended and anticipated that this really would be a redemption and the company would redeem the shares of a deceased brother. I don't think anyone really anticipated the cross-purchase. And you'll see that there's kind of a theme here of the brothers not following their own buy-sell agreement in the facts of the case. The stock purchase agreement in this case set the purchase price for a deceased holder's shares at a mutually agreed upon price to be updated annually. And failing that, they would obtain two appraisals to set the fair market value of the shares. I'm sure it will shock no one in this room that the brothers failed to set the value each year, and they never obtained any appraisals. Sound familiar? Of course, one brother passes away. It was the brother who owned 77% of the shares. The survivor did not purchase his shares. The company received the life insurance proceeds and redeemed the deceased brother's shares using those life insurance proceeds. It's important to note here that the executor did not get a separate appraisal, but used the redemption value as the value of the shares on the deceased brother's 706. It is worth noting, however, here that the lower courts did say that the buy-sell agreement in this case was not sufficient and effective to set the purchase price of the shares. It wasn't a fixed value, nor was it a determinable price. These were just, as the court said, mechanisms by which the brothers could set the price. So that's anecdotal, but it is important to note that the court was focused on the fact that there wasn't some kind of particular way to find the value other than just kind of this amorphous agreed upon price and then the appraisal that never happened. The IRS, of course, audited the estate, determined that the shares were undervalued on the return, and sent a notice of deficiency. The IRS took the position that the life insurance proceeds should be taken into account when valuing the company on the 706. The estate argued that the life insurance proceeds received by the company were directly offset by the company's liability to redeem the shares. The lower court in Connelly found that the life insurance proceeds augmented the deceased shareholder's estate, and they rejected the estate's argument that the value of the shares should not include the insurance proceeds because the proceeds were directly offset by the company's redemption obligation. So therefore, the court valued the shares at more than double what the estate reported. And they specifically stated that a willing seller would not accept the $3.86 million purchase price for the shares when the company was about to receive an additional $3 million of life insurance proceeds. Now, interestingly enough, in 2005, in the Blount case, the 11th Circuit found that life insurance proceeds received by a company upon the death of one of its shareholders were a direct offset to the obligation to pay the proceeds for the purchase. The court also noted in Blount that the life insurance proceeds are not the type of non-operating assets that should be included in a company's value. So now, fast forward to the Supreme Court, we have two directly conflicting circuit court cases. The Supreme Court, in a unanimous decision, upended this entire concept that a redemption agreement won't result in a change in value of the shares. The Supreme Court stated that the shares must be valued at the time of death, so before the buyback of the shares, and that the insurance proceeds were a company asset at the time. So the court, therefore, included the proceeds of the life insurance policy on the deceased shareholders' shares in the fair market value of the shares. In a footnote, the court did note that a company's obligation to redeem the shares is not necessarily an offset to share value. So they didn't say that a redemption can never decrease the value of the shares, but they said in this case it didn't, so we're not going to consider those other situations. So what are the practical effects of this, right? Number one, clearly increasing the estate value of the decedent's shares. This may either trigger an estate tax or increase the estate tax liability for the deceased shareholder. It also increases the cost basis of the shares in the hands of the purchaser. It also can result in an estate recognizing a capital loss upon redemption, or it could cause the business to have to cover a shortfall in not having enough assets to redeem. So we're going to take an example here. Let's assume for this example that the buy-sell agreement has a set purchase price for the shares upon a holder's death. In our example, let's say that there are two owners. They equally own a company. The company is worth a round number of $10 million. That is not including the insurance proceeds. The company goes out and buys two $5 million life insurance policies, one insuring holder one, one insuring holder two. And the stock redemption agreement specifically says that the company will redeem the deceased shares for a set price of $5 million. Stockholder dies, company receives the $5 million death benefit, but now, under Connelly, the estate tax value of the company is $15 million, right? It was $10 million before the proceeds were paid in, plus the $5 million death benefit. So now the deceased shareholder's shares are worth $7.5 million for estate tax purposes. The estate obtains a step up in basis to that $7.5 million number, but pursuant to the stock purchase agreement and the set price in that agreement, the estate only receives $5 million. But it must report on the 706 and it will be taxed on the $7.5 million value. So now this puts a lot of pressure on the executor as a fiduciary. Does he take a capital loss between related parties? And more importantly, there is a real disconnect between the amount received by the estate and the amount reported on the 706 and taxed. And that could be a real hardship. If we're taking the exact same example, but we're assuming that the purchase price in the agreement is now tied to an estate tax value or some kind of an adjustment clause based on an appraisal rather than a fixed value. Again, the company is worth $10 million before the death benefit is paid, $15 million after the death benefit is paid for the deceased shareholder. This results, again, in a $7.5 million value for the deceased shareholder's shares. But under the agreement, that's also the purchase price. So the redemption price in this case equals the fair market value for estate tax purposes. However, the company only received $5 million of death benefit. So now we have the opposite issue, right? The company has a shortfall of $2.5 million. They either have to use other assets, sell other assets, or potentially use a promissory note to make up that shortfall to the estate. I think our sense really is that this is likely what the court was referring to in that footnote that I talked about a few minutes ago. So if a company has to liquidate assets to pay for shares under its redemption agreement and in order to fill its obligation, perhaps at that point the redemption obligation will reduce the share value. But again, they didn't address it specifically, so that's what we think may happen, but it's just conjecture at the time. So what are our options, right? In this case, as you can imagine, kind of results in more questions than answers, particularly for existing redemption agreements. And I think if the one thing to kind of take away from all of this today is that if your clients have redemption agreements out there and company purchase agreements, that they really need to at least be looked at and kind of drill down on. I don't know that we're going to be able to solve all of the problems today, but, one option that I actually have read out there and seen out there is, you could just buy more life insurance on each of the shareholders to cover this. Well, then the company really is chasing its tail, right? Because we're going to continue to exacerbate the value of the shares, increase the estate tax value of the shares, increase the cost basis of the shares, but it also could increase the purchase price, depending on what the company agreement says and how the buy-sell is structured. And it may actually end up resulting in an underfunded agreement, again, in the second example we just used. So I don't think that, running out and buying more life insurance just for this purpose is really the answer, although I have seen that as an option. The other option, of course, is a cross-purchase, right? And as the name suggests, this simply means that each of the shareholders would own a life insurance policy on the other shareholders and would be obligated to purchase those shares when a shareholder passes away. Because the proceeds are not ever paid to the company, the proceeds will not augment or increase the value of the company in the shareholder's estate. But, this isn't an ideal situation because if you already have a redemption agreement and a company obligation, this may require the owners to go out and purchase more life insurance policies on their partners. Who knows if some of the stockholders or partners are not insurable anymore. If there's a discrepancy in ages, that could really put an undue burden on certain holders and not others. And the other thing to think about in just simply changing from a redemption to a cross purchase, of course, is the transfer for value rules, right? So you can't just necessarily transfer that life insurance policy to another holder from the company. If there are more than 2 or 3 holders, though, and I'm sure we've all kind of been in this situation, if there are more than 2 or 3 shareholders, having a cross purchase really could be a nightmare. And it goes up exponentially how many policies need to be, obtained. And we want to make sure in police that everyone is paying the premiums and that the policies are still in good standing. And so it really could be kind of a nightmare. But at this point, that's one of our only options to kind of ensure that we are not exacerbating the value of the company just by having the company have an obligation to purchase. What seems to be kind of the most touted fix at the moment is this concept of an insurance LLC. Concept is very easy. The shareholders of the company create a separate entity. They are the sole members of that LLC. And the LLC owns the insurance policies on each of the members/stockholders and is the beneficiary of each of those policies as well. Those transfers of insurance policies are excluded from the transfer for value rules here because if you transfer a policy to a partnership of which you are a partner, and LLCs fall under that definition for these purposes, then you are not triggering the transfer for value rule. So we could avoid that easily by doing this. It's kind of a means of getting a cross-purchase agreement without actually doing a cross-purchase agreement. Again, the benefit is that the owners would get a step up in basis when one of the other stockholders dies. When they purchase the shares, they would, at least with respect to those shares, get the step up in basis, and they don't have to run out and buy insurance on each of the other owners. And we're not increasing the value of those shares on the deceased shareholders' 706. But it's worth noting that you have to be very careful in drafting the buy-sell agreements and the insurance LLCs, because you have to ensure that you're designing it such that the insurance proceeds, once they come into that LLC, are only allocated to the surviving members. Because again, if the insurance proceeds come into the LLC and then they're allocated to all of the members, including the deceased member, we're kind of back in that Connelly vortex again, right? Where the value of the LLC membership interest in the deceased member's estate will include those life insurance proceeds. So we have to be very careful about that. I think the biggest question on the horizon for practitioners like us and people who are drafting these kind of agreements is whether the IRS is going to try to argue that this insurance LLC lacks substantial economic benefit and doesn't have a bona fide business purpose. If they're successful in making that argument, then they probably will be successful in including the insurance proceeds in the value of the members' interests at death, notwithstanding that the company does not have the obligation to purchase those interests. So that's kind of a big risk. It's out there. I know a lot of people are using these insurance LLCs, and I don't have a magic bullet right now, but I think it's important to at least talk to your clients about redemptions and ensure that if that's the way that they want to go, you really have to talk to them about the potential shortfall on the company side or kind of driving up the estate tax value. So I think the two things to really think about are cross purchases and use of these insurance LLCs.